Welcome to the Corporate Law Lab podcast. I'm Neil Taylor, Director of the Corporate Law Center at the University of Cincinnati College of Law. For our next few episodes, we will be joined by several of the expert panelists we've been lucky enough to secure for the 34th Annual Corporate Law Center Symposium, which will be held here at the University of Cincinnati College of Law on March 7th, 2025. First up is Beth Naylor of Frost, Brown & Todd. Her journey from litigation associate to a nationally renowned expert on product liability defense and litigation prevention is inspiring. We were joined for this episode by 4 of our corporate law fellows. In order of appearance, the student co-hosts were Brett Blair, Maggie Heingardner, Chris Caudell, and John Zhu. We all hope you enjoy the episode and that you will join us for the symposium in a few weeks. Welcome to the podcast, Beth Naylor. Thank you for being here.
Thank you for having me.
Thank you for agreeing to participate in the Corporate Law Symposium that's coming up in a few weeks. I think it's going to be a very interesting day. So can you just tell us just a little bit about yourself? We'll go into great detail, but where you're from, where you went to school, what you've been doing since.
Okay. Well, I was born. No, just kidding. I'm native Cincinnati. Grew up in Cincinnati. My father was an attorney here in town with a mid-sized firm. Went to Ursuline Academy and then Miami University and then Notre Dame Law School. Right out of law school, went with a very large firm. Interned with a bunch of firms in Chicago. But getting engaged and married took me to Milwaukee, Wisconsin, which, believe it or not, had a very, very excellent law firm that was world-renowned. Got a lot of great experience there for several years, and then, as everybody in Cincinnati does, moved back home. Free babysitting when you start having kids, which is important. And at the time, went with the largest firm in town, Frost & Jacobs, which you now know as Frost, Brown & Todd. So I've been with them since the 89, 90, almost 40 years in practice. And my career has really evolved over time. In the mid-'80s, when you got out of law school and you were going with a big corporate defense firm, all you said was corporate or litigation. And that was that. There was no subspecialties, no anything. You just took what came. And at the big firms, basically the litigators, which is what I chose, served at the pleasure of the corporate partners. So the corporate partners got the corporate clients, kept them happy, did all their deals, which is what you guys are hoping to do, made money for them. And then, gosh, when they had that pesky litigation that would nip them in the rear end, they called us. And so coming up, we did all kinds of litigation, a lot of business litigation, pretty much anything that any of the corporate clients would become involved in. Through the early 90s, kind of the practice of law started evolving into a bunch of subspecialties. And that goes right along with, if you look at a lot of statute and regulatory stuff, a lot happened in the second half of the 1900s. And
did the law firm start to divvy up into... The law firm I was at, exactly the same. When I started, It was, are you going to be a litigator or are you going to be on the business side?
Right.
And then all of a sudden we had 8 sections.
Yeah. I would say that it didn't become formal until sometime in the aughts. But, I think as a lot of, and you guys will find this as young attorneys, you yearn for something that you feel experienced in. So you kept, if you got repeat things where you didn't have to keep learning something new each time, and you felt like, oh, I can answer this off the top of my head. I don't have to go research it out the wazoo before I'm comfortable giving an opinion, that you kind of gravitate towards that. And in the early 1990s, Frost & Jacobs at the time really didn't have much of a products liability practice at all. And yet we had several corporate manufacturing clients who all of a sudden were really getting nabbed with products liability. Just real quick, background, the first concept of products liability was introduced by the California Supreme Court in the late 60s. People kind of hemmed and hawed about it in the 70s, and it really wasn't until the 80s that all the states started passing products liability statutes. So then, come early 90s, these manufacturers who basically would just put products out there and, if it was crap and you got hurt with it, sorry about your luck kind of deal, start getting a huge docket of litigation. And so that worked well for the timing of my career. And I pretty much started focusing in that area, largely defending lawsuits at that time.
So when you started, it was a patchwork of state product liability laws that you were generally dealing with?
It still is. Yeah. However, I would say that by this point in my career, I can tell you all 50 states has statutory products liability law, and they vary on only a couple of issues to a minor extent. Okay. So it was really easy then to take that knowledge and turn it into kind of marketing myself as somebody who could be a national counsel and help the manufacturing companies who at that time had very small legal departments, if any. Maybe just a general counsel and an IP person to protect their IP. That was it. Nobody that was really knowledgeable about litigation. And all of a sudden they have this huge docket of products liability litigation. So, it was very easy then to, if you had a product, and this is the way that it works, is, you have a product that you get sued on, you tend to get sued on it again and again and again. So coordinating, your defense strategy and the discovery that you're putting out in California with kind of the same claims in South Carolina and the same claims in Texas became very important. So coordinating that and not having just random local counsel around the country coming up with their own ideas and saying things that then we couldn't support or sustain in the other similarly situated cases in other states. So there was a huge need for that. And again, it worked out really well for the timing of my career.
Did you have a technical background at all? I
actually am the least technical educated person that you will ever come across on purpose. And the interesting thing about that was I'm going into a room when there's a case. I'm going into a room in the initial meeting to learn about the product with a room full of engineers. Engineers, I don't think very differently than lawyers, I will say. Very focused on, how things work, the performance and things. And the problem is they can't understand how we have to put together kind of a theory of the case and a defense and how we dumb that down for a jury. And so honestly, I sold myself on the lack of technical knowledge was a great thing because I'm your average juror. If you can't convince me of what you're saying and why the product's not defective, we got a loser of a case. Explain it to me and then ask them again and again and again. And, things that the engineers developed because they could and they thought it was great and revolutionary. Well, maybe it kind of made the product unsafe. And so then you would force the engineer to support the reasoning for that, which, kind of helped prepare you for the darts that were going to be coming at you in the litigation.
So
let me finish that. But you have to learn the product. So I will say that I'm a quick learn. I don't need to know how to actually design the product, but that's the one thing that I really loved about my practice is that you would go in and learn a product, learn how it worked, learned what it was used for. I would often then use it. If I could go out and buy it, I would buy it. If not, they would take me through some sort of training course. And actually, that was really fun because that was kind of the slight difference every time. Now I'm in an area of law that I feel confident in. I know I don't have to research every question, but I'm learning new businesses, new industries, new products pretty much with each client.
Did you find it difficult to translate those technical details that you had to learn to the audiences, or was that just part of your process that you learned it in a way that you knew you'd be able to explain it to a jury? Is that...
Yeah. First, I really, really pushed the engineers to try and dumb it down as much as the engineer could. And then try and take kind of the highlights that I think would be important for a jury. So big on why our society needs this product. What good the product does. Really push the utilitarian aspect of the product. And, then talk about the various different things. So it was a combination of working very, very closely with the in-house engineers. And that's the other thing that I find that to successfully defend a product, the people that develop the product and market the product, the inside people are the ones that know the product better than any outside expert you can hire. Now, having said that, sometimes you do have to hire an outside expert, but my first go-to is always the inside people. Sorry, Brett, did you kind of raised your hand? Yeah.
So I know you deal primarily with products liability litigation. Is there ever a time where maybe the engineers will pull you in prior to releasing a product to market, just to kind of get some advice for, to maybe prevent litigation?
Yeah. So that was the next big evolution of my practice is, as I told you, the timing was wonderful and the client base was wonderful to become a national coordinating counsel for a lot of manufacturers. It didn't take very long for most of the companies to realize we would really rather not have a big docket of litigation. Can you help us now that you know all of our, warts and vulnerabilities and everything? You've seen the good, the bad, and the ugly. Can you help us change our processes, dot our I's, cross our T's, so that we eventually get rid of this big docket of litigation? That sounded really interesting to me, But in the back of my mind, I'm like, working myself out of a job, because if they don't have a big docket, I hope you're going to keep calling. But so that was the evolution into the preventive product safety and then the regulatory compliance work that then I've pretty much been doing for the last 20 years. And, from a business perspective, which you guys will be the in-house business people, nobody likes to be spending money on litigation. And even if you are, insured, and there's a lot of differences between being self-insured and having an insurance policy and how they defend your products and how much involvement you have if you have insurance. Those are all huge strategic issues for a company. But regardless of whether you have insurance or you're self-insured, or you've got nothing, you just don't want to be dealing with litigation because I use in-house people. It's diverting your engineers from what their primary role is. And, they're all angsting about having to give a deposition and stuff. It's just a huge distraction for the business who is in the business of developing and manufacturing and selling products. They don't want to be bogged down by litigation. So that's where, with one particular industry where I was in the late 90s, pretty much spending all of my time because at the time it was called the American Trial Lawyers Association. What are they? They're called something different now. But it was basically the National Plaintiffs Bar had identified this industry as a vulnerable industry to attack because the products could cause severe injuries, and it was a small industry, and they really hadn't been challenged on a lot of safety issues and things like that. So I was spending a lot of time in that industry, and then, representing several clients in that industry so that I would be at trade association meetings, talk about, how can we as an industry come up with voluntary product safety standards so that we are now being proactive with regard to the safety of the products, and moving forward there. So great question, because that's exactly how it evolved.
Ask a question?
Maggie.
This was actually one of my. Okay.
Oh,
Sorry.
yeah, sorry.
Thank you.
Thanks for the reminder.
Yeah. This actually was one of my questions, but since we're talking about it, and we talked about like the preventative aspect, but also, and since you talked about like, you ask, why does society need this product? Like, how do companies, or how do you advise companies to like maintain their brand integrity after a crisis or a product's liability case occurs?
That's a big part of where I am now as kind of a much more senior counselor and advisor. I'm not putting out a whole lot of work product these days. I'm strategizing with upper management on things like that, and it becomes very very difficult on depending on the amount of publicity that you're going to get. You know, if you decide to litigate a case to verdict, and you get nailed big time, guess what? It's going to be in the media. If you're a company that has a recognizable brand, it's going to be in the Wall Street Journal. It's going to be in the it's going to be in mainstream media. It's not just going to be for law nerds who read, verdict reports. So, that is a huge part of decision-making, especially these days with the internet. It's before there's even a recall or litigation, because you have these chat rooms where dissatisfied people are just getting angry. And, they're creating a lot of negative stuff, just online without there being any sort of formal process. Additionally, a lot of the, or most of the main regulatory agencies, federal regulatory agencies that I deal with, so the Consumer Product Safety Commission, the FDA, and NHTSA, that regulates automobiles, have websites where, if I'm sitting here today and I get, zapped by this microphone, I'm like, oh, that's unsafe. I can literally just go online. I don't even have to have an injury. Say, oh, I was sitting here and I think this microphone's unsafe, and I'll have the brand name and everything. And it's all there for God and everyone to see. And anybody that wants to can go in and mine that data. So brand integrity is a huge part of, in my view, the evolution of businesses to wrap their head around the importance of preventive product safety. You do not want to get in a situation where you're blindsided by, a front page article, something went viral on the internet. The regulatory agency saying, well, you guys were supposed to bring this to our attention, but since you didn't, now we're going to order the recall, and it's going to be a big deal, and it's going to be, hundreds of millions of units across the globe. You really don't want to get there. So, good question.
One of the things you talked about is taking the case through trial and winning or losing, and how awful that is. I think a lot of businesses didn't realize, at least when I was starting, that taking a case through trial and winning often feels just as bad.
Yeah.
It's great to win, but then, you've got people out of the business sometimes for weeks on end. There's the cost. There's still publicity around the fact that you went to trial. Mm-hmm. And so it's, that was my focus when I was in-house. Managing litigation was to try and stop it from happening. Yeah. I had this massive portfolio of litigation, and it looked like, wow, this is great. I'll be, this is a lifetime employment, and managed to whittle it down over time, which actually gave me the opportunity to do other things within the business, as opposed to just being the guy who was always in a settlement conference in El Paso or Milwaukee or wherever I happened to be, that week. So it's one of those things companies need to think about is, litigating, if you could have avoided it early on, is almost always a bad idea.
I will agree to an extent.
Yeah.
What you say about litigation is absolutely 1,000% true. Is nobody other than the best trial lawyers in the world love or even want to do again go through the litigation experience. It is just a bizarre, stress-filled time suck, basically. And just a short little story. I remember when my kids were young, we had this big case. It was in Cincinnati. It was being covered by the media. And it basically took me out of my normal life for over a month. Just the immediate prep, the actual trial, post-trial motions, verdict, everything. We won. Okay. And the rest of my life had been on hold, right? And I killed myself. I think I was a senior associate or junior partner. I mean, I wasn't in charge at all. And I'll never forget the CEO of the company, last meeting, done, shaking hands. And he goes, "Thank you so much. And I hope I never see you again."
Every client's favorite day is saying goodbye.
And I
to
do
their
think
litigation.
I was a junior partner at that time because, when you become a partner, you start thinking, well, how am I going to develop business and have, my good work continue to generate more business? And I go, well, that's a really bad business development model. Even when you win and kill yourself, they never want to see you again. They never want to have to call you again. And so that's true. I will say with that one industry that I was talking about in the late 90s is, they weren't going to go away. They were going to continue to shake down the industry for settlement as much as they can.
Until you were willing to show you tried a case.
So at some point you have to put a stake in the ground. And the way we dealt with it, and I don't know how you were able to whittle down your dockets, but the way we dealt with it is through the trade association. The major players in the industry, the legal teams got together, aligned the strategy. And we also took what I called kind of a Supreme Court approach to the cases that came in. And so we came up with kind of our perfect case. Okay. And it wasn't going to be the big injury case. Too much emotion in that, right? So it'll be kind of a minor injury case, a product that we know we have all the documentation, all the quality tests. We came up with the criteria for the perfect case. And we would assess each case that came in along that criteria. And the case that would be perfect we would spend much more than the economic value of the case. Even if they hit a home run, they would have maybe only because it was a bad thumb or something, mm-hmm. They would have gotten a relatively low amount. But we decided we're taking that to verdict because we think we have a much higher chance of prevailing and shutting this down and making the plaintiff's bar spend a lot of money on a case that even if they hit a home run, they're not going to make much money on it at all. They're going to wind up spending more than they're going to recover because all the plaintiffs have it on contingency. So we became very, very methodical about which cases we absolutely would not settle and which cases we would. And I know that strategy works because one of the attorneys that was holding the seminars at the plaintiffs' attorneys like conferences about how to cases against the industry, one time at a deposition, finally got up and he said, we're done. And then he said, you're just making this too expensive for me. And then he never filed another one. So sometimes it's not about the merit of an individual case. It's not about the legal issues. It's just about the practicality of the situation. How can we turn this around? And
you sort of asked the question, so I'll take the opportunity to answer it of how we whittled the docket down. Partly it was by showing we were willing to try the occasional case. Because I would go to settlement conferences and the demand would be based around how much you're going to have to spend to defend this case. And it's going to cost you $250,000 to take this through a 2-week trial, or $500,000 through a 6-week trial, whatever it was. And we're only asking for half of that. Give us our money. And our view of it became, well, if we do that, then we have to settle them all, whether there's a real cause of action there or not.
Yeah.
If we just always put defense costs in, so we would try. At first, it was one case a year. Then it became once every 2 years. But we always had a recent trial that we were pretty sure we were going to win.
Mm-hmm.
Occasionally, you get that wrong.
Yeah.
And then I could sit there and say, in a settlement conference with a grumpy federal magistrate, no, I'm not going to put defense costs or any portion of it on the table. I'm going to negotiate based on what the case
Right.
is worth. And eventually we became less of a target.
Yeah.
And that helped. People understood we would actually try the case.
Yeah. If you just settle everything, you become shakedownable. And everybody knows that. The one area that I will tell you it doesn't always work, which is another industry that I represent clients in, is in juvenile products. It becomes very, very difficult because no matter the situation, you have an extremely sympathetic situation with an injured child. And oftentimes the parent or the caregiver are very loving, but they didn't use the product exactly right. And, that I would tell you that juvenile product manufacturers and by extension, some of like the biggest brands, let's say like McDonald's and things like that, they have decided as a business strategy that they never want to go on record as, having to litigate against, a baby who's going to be, disabled for the remainder of their lives. So, it also depends on the product and the industry and your customer base. I mean, there's just a lot. It's very interesting to me because I will just be upfront. Products liability law is not the most heady legal principles in the world at all. If you're like a true legal scholar, that's not your area. But what's very interesting to me is it's much more about human nature and, understanding the practicalities of the product and your customers and how all this is going to play into your ultimate business strategy. Very similar to the question that Maggie asked about brands.
Yeah, I mean, I can imagine if your best defense is the child's parents misused the product, that's got to be a very hard sell to a jury.
Well, it is, but it's a complete defense in pretty much every state.
Yeah.
But it's difficult.
If you lose the summary judgment motion,
Yeah.
you really don't want to try that case, right?
Right. Yeah.
When you served as national coordinating counsel on these cases, you were sort of a hybrid, I guess, between being in-house and outside counsel because you're then trying to manage other lawyers. Is that fair?
That is exactly fair. And so actually my springboard into doing the National Coordinating Council was a local manufacturer of power tools here in Cincinnati that overnight all of a sudden had a docket of 36 cases, and they had a general counsel who did deals and an IP attorney, and they were just hyperventilating about what to do. And the general counsel, who I'm still friends with today, was very visionary, and he said, I can't see actually hiring another attorney to deal with this because I believe that it's temporary. I think it's just something that we need to get under control. And so at that time, it was very new. He said, can I hire all of your time for, let's do it on an annual basis. And, at some point when, we get this under control, you're still a partner at your law firm and and we're under control and we'll still be a good client and things. And, that had tremendous attractiveness to me because right away at the beginning of the year, I could tell my partners, okay, this is how much I'm going to bill and this is how much I'm going to bring in this year. So it worked out well. It kind of got me under actual billable hours, which if you do go into a firm, will know very quickly is the bane of your existence. And so I actually sat in their legal department, had people coming into me with all sorts of questions, not even just products liability, which actually turned out to be a really, really good marketing and client development situation because I could cross-sell my other partners in other areas. And then I developed a network of local counsel around the country that once we got that client's issue under control, and then I was national counsel for other clients and other industries for other products. But I would have this really good tried and true network of local counsel. So sued in Texas, no problem. I got the guy. Sued in Southern California, no problem. I got the gal. It was, to this day, there's I'm closer to some of them actually than, some of the people in our firm.
How did you find them?
Very difficult because it was before the internet. I mean, you guys never lived in a world like that, right? So I went to Notre Dame Law School. I first started with the Notre Dame Law School directory, looked up the town, saw if there was anybody that I knew that had been in law school when I was there. You send a note around to everybody in our firm. Hey, does anybody know a defense attorney in Cheyenne, Wyoming, and maybe you'd get a couple hits there. When the internet first did start, I would try and do an internet search. And this is going to be a plug for diversity and equality in our profession is, so this is mid to late 90s. So in my world, not that long ago, I would put in, products liability defense attorney, Cheyenne, Wyoming, and 10 times out of 10, I got a middle-aged white guy that, I'd call around to a couple people. I'd ask about each other and, oh yeah, he's the guy. And so then I would retain that individual. And after the first call, I'm working with the superstar female senior associate or junior partner, who is who I wanted to give the business to anyway. But somehow the algorithm from the firms was not showing her to me. And I'd like to see if hopefully that's changed. I don't really know if that's changed. But that actually was what really, really got me involved in. If you've looked at my bio, I became very involved in developing the first women's initiative here in the area in the late 90s. And, the rip against women and having them be partners or being compensated fairly as partners. So, they can't generate business. Well, if the firm's algorithm isn't putting me out there, of course I can't generate business, right? And so really focused on, women can develop business. They just have to have the same equal footing as others. And I knew that we hit a raw spot when I had the chair of my practice group one time in the aughts say to me, you women just give all the other women work. And I just don't know how we're supposed to do it anymore. I'm like, well, welcome to our world for the last 3 decades. And I go, I give it to the best person. My network is probably about 50-50, which is good, honestly, from a diversity perspective. I said, but, that's not accurate. It's just now you guys have to compete a little bit. So come compete with me. I'm not afraid of competition. It's just, you guys don't get all the advantages. So anyway, I'm sorry, I diverted. It wasn't on the outline, but I couldn't leave that one.
the outline isn't there for any other reason than to make sure if we have a lull in the conversation, I know what to say next.
Okay.
So you go wherever you want to with with our questions. I also was thinking as you were saying that you probably also saved your client a lot of money by not taking the senior partner whose billing rate was probably twice that superstar junior partner or senior associate that you ended up actually working with. So
exactly. We are, I come from a family of all girls, but somehow we're a really big football family. And my husband played college and pro. My nephew actually plays for the Bengals now. But and early on, my sisters and I, we were sports. And I did find at that time that was unique. Sports really gave me an advantage to compete when a lot of women my age had not necessarily been involved in sports. So, I mean, that's all old news for you guys and your generation, but for my generation, that was really, really important. And so the way I looked at setting up our team was that I absolutely did not want the full of himself, arrogant senior partner in Cheyenne, Wyoming, because he was going to do whatever he was going to do. He wasn't going to listen to me. And I had decided, with authorization from my client is, okay, like I am the quarterback of this team. So don't you be coming in here thinking you're going to take my position. And I needed, a couple good offensive linemen. I needed the young junior partner or senior associate was my 3 down running back, so that's kind of the way that I looked at it is everybody had their role. And if I got the wrong person who was trying to duplicate, well, that was the surest way for me to lose the trust of my client. If he would, start looking at my bills and the local counsel's bills, and we're doing the exact same thing and he's having to pay twice, guess what? He doesn't like what I'm doing, right? So, it was very important that the team was well drafted and everybody knew their roles. So not only was it a money saving, it operated just a whole lot better that way.
So how did you decide then which decisions, stick with your analogy, which are quarterback decisions and which ones can you trust the offensive line and the tight end to know what to do?
Yeah. So it was anything having to do with local law, local procedure, relationships with the local judges or local opposing counsel. And oftentimes I would give them the damage side of things. The quarterback kept all of the intimate knowledge about the product, why it's not defective, the quality testing, the other litigation, the in-house people, dealing with the actual client about the product and the industry was kept within the cone of silence, and the playbook was the same pretty much all the time, right? And so the other folks would be very, very local specific, state specific, or damages. And the reason why you would say, well, damages could be a big deal. And sometimes that would modify if the damages had the potential to be huge. So major brain injury or something like that. But if not, in a products liability case, if the jury finds that the product is defective and that defect caused the injury, you're toast, right? So it's not just it caused a little ouchie as opposed to a big ouchie. And so to me, the damages we had to win on liability. If we lost on liability, the damages were going to be what the damages were, because we weren't winning because we could cut out a couple medical bills, basically. So that's the way we did it, by order of priority and then geographic expertise.
So your time sitting in-house, did that change how you worked with other corporate counsel? Did it have an influence on how you approached dealing with other GCs and other companies?
I will say this as an absolute statement, which is rough because most things aren't absolute, is that experience sitting in-house pretty much made my career from there forward. Because if you come out of law school and go to a firm, you never really know or understand the pressures that in-house counsel are under. You don't know how it operates. You don't know, kind of their management structure. You don't know how they're evaluated. You don't know all the pressures that they're under. You have no idea. You're so focused on this one big case that you're billing 20 hours a day to. You can't understand why this person who has 1,000 other things going on doesn't want a 10-page assessment of a minor issue. That just doesn't compute for you, right? So actually being in that position changed the entire way that I dealt with in-house counsel. And it was very different than the way that I had been trained, the way that a lot of my partners did business. And I do think that it's made me very successful. Things like, and I teach my associates this. I said, when you're communicating to in-house counsel, you never say, attach, please find. That means that they got to click again and open the attachment and this, that, the other thing. You say, attaches the ruling on such and such motion, and then 3 to 5 bullet points if it's a big ruling, right? But 3 to 5 bullet points. And so they can decide, oh, you know what? When I'm on a plane, I'm gonna download that and read it. But they don't, to see what it is, they don't need to do it. So just, again, nothing having to do with the law, just very, very simple things because you understand having stood in their shoes. So yeah, absolutely.
Yeah, as a GC, I don't know why it was hard for people to understand that the most important thing I wanted to know was the answer.
Yeah.
I've asked a question, maybe how did the hearing go, or what was the ruling on that, or what do you think is likely to happen here? Tell me the answer. If the answer is on page 4 of your memo, I'm angry by the time I know the answer, even if it's the answer I want, right?
And that, honestly, I think in the time that you and I have been practicing has been an evolution. So, when I got out of law school in the 80s, you researched something out the wazoo because your answer had to be exactly right. If you missed a case, man, you were getting chewed out right and left by a judge, a senior partner, whoever. But you, and you had the time. I was just telling Neil, when I started practicing, we didn't have desktop computers. I would handwrite out a brief and then I'd have to leave it at night for the word processing center. Then the next morning I would have a draft of the brief. I would edit the brief. Then I would have to leave it the next night for the wood. So the speed at which things happen now, it used to be you absolutely had to give the right answer. Nobody wants. There is no one right answer anymore, and there probably wasn't back then, but we just all were so full of ourselves we thought there was. But the question that in-house counsel will ask now is, if I am able to give you 60 to 70% of the known facts, and you're not going to get the other 40 to 30%, can you give me your gut and be comfortable with your gut? And there's a lot of lawyers that will not do that, are not comfortable doing that. I can shoot from the hip. Well, and that becomes easier, obviously as you've had more experience, and it helps if you're in an area where you kind of know the area and have developed an expertise. But the focus is more on kind of, what's your best guess? I mean, they're even asking, like, what do you think will happen? What's your best guess? And they don't want 10 pages of caveats. They just don't. They want to be able, the speed with which businesses are making decisions has just increased unbelievable. And lawyers who aren't able to keep up with that, I mean, you guys will be going at lightning speed, and I'll be well retired. But you have to keep up with that, because if they ask you what they think is a mission critical question, and they've got to make a decision the next day, and you tell them, "I'll get you a 20-page memo in 2 weeks," yeah, they're not going to call you again.
Agreed. And the other thing that would drive me absolutely insane is if somebody told me there was a 50-50 chance of something happening. I would literally say, and I would use other words in addition to the ones I'm about to use, I have a coin. I know how to flip it.
Yeah.
There must be something I'm getting out of this conversation that is more than reaching into my pocket and flipping a coin.
Yeah.
And that was strangely hard for some lawyers to understand, that I wanted them to take a position. That's why they were there.
Mm-hmm.
And I wasn't going to, when I started practicing, I'm sure it was similar for you. We were more afraid of malpractice than anything.
That is true, because that was kind of a new thing.
Yeah. And the amount of memos to the file that I wrote in my first 4 or 5 years of practice, I had a conversation with Beth. Beth told me to do this, so I did it.
Yeah.
And it's like, I can't imagine that those things actually still exist. Now it's probably an email,
right?
Confirming our conversation, this is what I'm doing.
Yeah.
But back then, you'd write out that handwritten memo, send it to the typing pool, it'd come back, and it would end up in the file, and the file would be this thick, and the client would be saying, "How did the file get so thick?" It's like, well,
yeah, CYA.
Right. Our thing is about protecting ourselves from you.
Yeah.
Which would drive the clients
that's
nuts.
a good point. And I think it's really important for you guys, especially if you guys wind up being in-house counsel or, more transactional type people, is what I've come to learn. It really, really kind of, again, it was an evolution. I'm going to say over the last 15 to 20 years is, all clients aren't created equal. There are good clients and bad clients. And now I can almost tell from the first conversation whether it's going to be a good client or bad client. And if you're a good client, you will get every benefit of the doubt. Am I going to mark down a 0.2 or a 0.3? You're going to get the 0.2. If you're a bad client, you're getting the point. You're going to get not a 50-50 answer. You're going to get, I think you have a better than 50% chance. And if we win these motions, that increases to 75% or whatever. So, it's really a partnership. And in-house counsel that don't understand that and don't similarly respect the pressures that outside counsel is under, aren't going to get the benefit of the doubt. The number one characteristic of a bad client is the client who you can tell that if you said 75 and then you lost, that they were going to get you, fired. They were going to tell the senior partner. They were going to sue you for malpractice. They were going to squawk and complain, and they're complaining about everything, every bill. Let's go through line by line. That type of client is not there to be part of the team, and sometimes you still have to work with them. But right away, I'll tell my team, okay, this is a client that we've got to mind our business on, or this is a client that, really gets it, really understand we can have good conversations, about things. And I will tell you, every single project, the good client gets better work product, better result, oftentimes cheaper. I mean, seriously. So if you are in-house, be a good client. Be a good client.
Well, and sometimes they're forced to do what are really counterproductive things. Yeah. I remember I had a set of billing guidelines, and I was very proud to say that intra-firm conferences are expected, not prohibited. Because,
wow.
But why in the world would I not want the young associate Maggie to walk down the hall and ask the partner that's been doing this for 40 years the answer instead of spinning her wheels for 4 hours because she's not allowed. She knows that I'm going to mark out on the bill an intra-firm.
You're preaching to the choir. You're preaching to the choir. I don't.
Well, and I think it also just, it causes a level of basic dishonesty between client and lawyer. Because you can't run a team that way where they're not allowed to talk to you. So, when you're going through the bills.
That's never the answer.
Right.
That is never the answer, yeah.
Right. So instead of, I had a 0.2 intra-firm conference between Maggie and Beth, what instead you see is that you were both strategizing on the same day. And it's like, okay, maybe the software with now AI, Elon's found a way to catch us doing that too. But I doubt it. And I just felt like and part of it was I came from private practice and I understood and still had some sympathy for it.
Yeah. Yeah.
I probably developed less and less of it over time, especially as I moved away from litigation and into deals. Mm-hmm. So, we'll get some of the people that worked with me on the podcast someday and see if they agree that I was the good client and not the bad client. Who knows?
So one area that is on here, and I think it's kind of really important for you guys, is my practice as it evolved was not anything that I ever thought of, could even imagine, or don't even know really if it existed at the time that I started. But I think we do understand now that that regulations are really important for businesses. And I think one of the questions was, what class do you wish you would have taken and you didn't take? And I'd have to go back and look, but we probably did have an administrative law class. I don't think I knew anybody that took it. I don't even know who taught it. I probably didn't even know what it was, right? But as it turns out, boy, that would have been extremely helpful for me as my practice evolved. And I will tell you, especially if you're going to be corporate counsel, regulations are going to be so key to business strategy. So right now, I'm dealing with, I'm going to go back to the office and help a client prepare for a submission to the FDA because they've gotten far enough in the warning process that they're probably going to be shut down because they haven't been following the regulations for the production of soap, which is technically a drug, and cosmetics, which is also regulated under the FDA. And it's a company that, kind of went through a couple private equity changes and, private equity dudes. And I say that lovingly because my son is one. It's all about, cutting the margins and turning the profit and this, that, and the other thing. And maybe didn't really have a grasp on the importance of really complying with regulations. Or if you think the regulations are wrong, now in this new world of no Chevron deference, challenging the regulations, right? But to me, that is much more of a corporate function rather than any sort of litigation, even though you might eventually have to end up in litigation over it. But setting the business strategy, if you're in any type of regulatory world, and believe it or not, the majority of the manufacturers, a lot of them offshore that manufacture consumer products. And you might say, what's a consumer product? Like every damn thing in Walmart is a consumer product, So, and the majority of these manufacturers have no idea they're regulated. They are regulated by the Consumer Product Safety Commission. Now, it's self-regulating. You have to self-report. And that's why they think, we don't have to get pre-approval like you do in the FDA for drugs, right? No, you're still a regulated product. It really, I've learned it's so critical to kind of the business strategy. And as a good corporate counsel with legal training, which is what clients like to hear. They don't want you to be a lawyer first. They want you to be a business person first with legal training. That is very important, understanding what the regulatory landscape looks like for your particular business.
Chris, you have a question, I
Yeah.
can tell.
I've been dying since you started talking about regulation. So earlier you mentioned voluntary safety standards, how it's kind of formed a big part of your national practice based on the scope of your work. Have those voluntary safety standards been able to really influence that regulation that you see? Has that formed part of an industry's just like standards that they operate on now because you've been able to participate in that and see the real genesis of the practice over time?
Yes, very good question. So there are a lot of unregulated products in our commerce around the world. And in these unregulated products, and a lot of them are, kind of business to business products that you'll find in a workplace or something like that. The industries, in my opinion, are very well served by developing their own voluntary standards. There are, and you've probably heard of them, there are standards developing organizations around the world that provide the framework for you to do that. So one is called ANSI, the American National Standards Institute. We use that a lot here in the US. ASTM, American Standards and Technical Materials, something or another, where experts and people in the industry are coming together and saying this should be the most minimum standard that we have. Let's see, there's also ISO, International Standards Organization, that is based out of Stockholm, which Stockholm is my favorite place to visit. And I go there a lot because I'm on working groups for the ISO standards as they develop. A lot of the work that I do now for the clients is not necessarily, the actual litigation or work product, but I will sit on the standards development boards and work groups to help provide kind of the minimum standard. And it really, really does, it does work. It actually puts an advantage on the competitors that really want to put out a safe product from, other stuff that's coming in. There's no enforcement mechanism. So you might have manufacturers that are complying with a voluntary standard, and then you'll have some, cheap stuff coming in from offshore that doesn't comply, and then they get all worked up and this, that, and the other thing. But there's no enforcement mechanism. But I will tell you what, when it comes to defending your product, if the regulatory agency comes knocking or litigation starts, being a kind of a regular occurrence, when you can say, this is the safety standard and we comply and exceed it, that is a very strong defense versus somebody saying your product is unsafe. And then we're like going, well, yeah, it is safe. Well, how do you know? Well, we just think it's safe. There's no standard associated with it. So actually, I've had 2 or 3 industries where I've worked with a client in the industry and there was no standard, which makes the defense very, very difficult. And I shepherd them finding the right trade association to then work with the industry to develop a voluntary standard. So again, sitting in law school, me helping write standard, that's not something that I love. But if you think about it, it's very, very critical to being able to explain to a regulatory agency, the thought process and the science and the testing that went behind all of this. And here's what the industry says, and just kind of saying, well, we've been doing it for 100 years. What's your problem? They don't like that. Yeah.
Speaking of regulation standards, do you ever see like overlapping or even conflicting regulatory standards between the states or maybe federal level?
So here in the U.S., of course, we have, federal regulations, and then we have a handful of states, and I can tell you who that handful are: California, New York, Oregon, Washington, that are actually more stringent than the federal standard. So yes, there's always this patchwork that makes things somewhat difficult. But where I thought you were going to go is that you have these different standard organizations around the world, and most manufacturers now are distribute globally. And so when I started working with a lot of manufacturers, so a manufacturer based here in Cincinnati, well, they have to have the exact same product, but they have to have the version that goes into the EU. They have to have the version that goes into Japan because Japan has their own standards. You have to have the version that goes down to Australia and New Zealand, and then you have to have the North American version, which is very, very ineffective and
inefficient
and costs a lot of money and everything. So there's a huge move. And again, this is taking me to really cool places internationally to harmonize. Like, so if an industry has an ANSI or an ASTM standard here in the US, and then there's a separate EU standard under the ISO umbrella to try and harmonize those standards. And it's a glacial process, I will tell you. It's moving very, very slowly, but the goal is to harmonize. And I'll tell you why that's important is actually here in the US, we have this industry safety standard and we say we comply and exceed, the standard. But now the plaintiff's attorneys have access to enough information. They go, yeah, but you ship a different product that's safer to the EU. Or a different product that operates differently that would have prevented this accident down to Australia and New Zealand. And then when the jury hears that, they're like, well, crap, don't we get as safe as product as they do in the EU and Australia and every place else? So it's very important, I think, to harmonize globally because it doesn't make sense to have different levels of safety with the products that you're shipping around the world. So there is that goal. And also some of these industry standards, like this just happened with a client of mine. There was an ASTM having to do with fuel cans. So I don't know if any of you guys work on your cars or whatever. You go into O'Reilly's or Napa or whatever, and you buy something that you put into your gas tank that makes your car go vroom vroom better or something. And sometimes in a wrong situation, the vapors will be such that it'll be flammable or explode or whatever. So the standard was what kind of opening you had to have that would prevent those vapors from potentially causing an explosion. If you're just like a teenage guy that got his first, car and wants to go put it in his gas tank, but isn't really following the instructions or whatever. Well, it apparently was such a problem that the Consumer Product Safety Commission decided to adopt word for word this voluntary industry standard and make it actual regulation to have the force of law. So now there is enforceability, et cetera, et cetera. So that's how.
And then that case is really easy to defend now, if you've complied with that federal standard.
Yeah.
So you mentioned about law school and the class you wish you had taken. If you got to go back and have a chat with the first or second year law student that you were, what would you tell yourself? Don't stress about that'll be fine, or you should stress more about this.
That's a really good question. I had a really good time in law school, but there were definitely stressful times. I would have to say that probably even more so with you guys now because there are so many different areas of specialty. This has gone by the wayside, but there was a decade there where we were making kids out of law school choose exactly what's practice group, what narrow specialty. Are they still asking you guys to do that? That you want to go into?
I don't think they know yet. Do you know yet?
Okay. Well, that's the whole point, right? And so, guess what? The products liability practice group is hiring. What practice group would you like to go into? It's kind of crazy. And the one thing that I will say is that, trying to decide what, like even when all I had to decide was, do I want to do deals, transactional corporate, or do litigation? The stress of like, well, what's the right choice was pretty overwhelming. And what I will say, and you guys probably know this now, back then, you went to a law firm and you pretty much stayed there your whole career. There wasn't this moving around. You guys have seen that, you gain knowledge here and then you go there and you get more knowledge. And honestly, a lot of my mentees, to my disadvantage, because then they didn't stay at the firm, they went, but sometimes they were clients, which was good. But what's going to be important for you guys is to broaden your skill set. So bottom line is there is no right or wrong answer to that. You take a job. It seems interesting. It seems good. You gather skills. You get experience. And I would even say to my kids, no experience is bad experience. The experience might be like, hell no, I never want to do that again. But you learn something and then you move on to something else. So I would say probably the thing that I wouldn't stress about is kind of that first job. Like, is this the right thing? Because you guys aren't going to be in that job your whole career, much less a couple of years if what I'm observing amongst this group. But continuing to broaden your skill set and take on new things, just like Neil said, is, saying yes to things and learning it. You guys are going to be constantly learning. And the person that has the broadest, I think, person with the broadest skill set, when they die, wins. It's no longer like how much you have. It's how broad is your skill set?
Anyone have anything else? I think that's a wonderful place to end. We are right at just over an hour. It's amazing how quick an hour goes, isn't it?
Yeah, no, it was great.
Conversation.